Item number, call the list. Mentioning.
Yes, inclusion.
Mentioning.
Mentioning.
Yes, what you want to mention?
My
lord,
second April, my lord. Lordship has determination on the criminal revision, my lord, of 2024, my lord. Kindly include
Kindly
for inclusion.
come close to your mic. Na?
It has not been admitted, my lord.
Oh, did you serve notice
No, it was.
of mentioning?
Then, my lord, may I serve a notice and.
Yes, yes. Mention on our notice. Otherwise, no.
my lord, may I be permitted to mention item number 50, my lord, of today's list, my lord? My lord,
Yes.
since the matter is only pending for the, my lord, for withdrawal, my lord, I have filed application for withdrawal as per your lordship's order, my lord. So, lordship, I am only beseeching that may this matter be taken up at 3 p.m. today, my lord, or as per your lordship convenience, my lord, or
Item-
tomorrow, my lord.
Item 50.
Item 50, 50, my lord.
50. Okay. एक काल के ये
Deeply obliged, my lord, deeply obliged.
withdrawal ठीक है
Deeply obliged.
it already who is for the other side?
My lord, other side is my lord, Shriyoshi Vishal is appearing for the state, my lord, and Mr. Tanmay Chaudhary is appearing for the opposite party, my lord. My lord, in the meantime, I will serve them, my lord.
Okay, will matter appear in list tomorrow. आज को
Deeply obliged, my lord.
For the petitioner, I want to withdraw this application. The client has given me a letter.
Where is the letter of your client?
Mentioning
Did he file? Oh. Where is the mentioning slip? Within top room. This matter appear under the heading of to be mentioned. At the instance of learned advocate for the petitioner. The learned advocate for the petitioner raised for withdrawal of this criminal revision as per the written instruction of petitioner Sangnik Chaudhary. The said written instruction is annexed with mentioning slip is taken on record. In view of the above prayer, let this CRR 4574 of 2024 be dismissed for non prosecution. Hmm. The interim order or orders, if any, be disposed of accordingly. Any application, pending application? Disposed of, huh? If any. Stand corrected. Keep bolam. Sorry. Yeah, stand corrected.
Number 2.
I am for the state.
Well, I'm for the petitioner, my lord.
Hmm.
Herein, my lord, I have assailed an order whereby we had made an application for relaxation of one of the conditions of bail. Our prayer for relaxation of that condition was
Who is
turned
for
down.
the state?
Well, I am for the state.
You are for the state.
Yes.
Led by
And
my
any
father.
private?
No, no, no. Now, my lord, at page 20, at page 16 of my application is the order of grant of bail, my lord.
Hmm.
That is order number 32 dated 14/11/2022, page 16.
Page 16, let me come. Yes.
That is the order, my lord. The operative portion, page 17. The second last paragraph, my lord.
Yes.
Wherein the conditions were imposed upon me. The paragraph starts with accused petitioners.
Hmm.
Yes. Fourth line, my lord. On the condition that they shall appear before this court on every date of hearing without fail. While on bail, the accused petitioners shall remain within the city of Kolkata and provide the address where they shall presently reside to the investigating agency as well as this court. The petitioners shall deposit passport, if any, before the learned CMM Calcutta prior to their release. The petitioner shall report to the investigating officer once in a week until further orders, and or giving attendance to the They shall not leave the jurisdiction of the municipal limits of the city of Kolkata except for the purpose of giving attendance to the investigating officer, and they shall not intimidate the witness and not tamper with evidence.
Hmm.
Now, my lord, the only condition with which we were agreed was that it was difficult for us to maintain ourselves within the municipal limits of the city of Kolkata. All the other conditions about appearing before the investigating officer as well as the court, we are doing that. The only
Yes.
thing, my lord, we are aggrieved by is the restriction to stay, my lord, because we are poor cultivators. We reside at Raghunathganj.
Hmm.
As such, my lord, we were in custody for about 3 years. We don't have any other means of livelihood. So in Kolkata, my lord, we were facing difficulty. So we only wanted the relaxation of that condition only.
Yes.
We made an application before the learned trial court, which has granted the bail, and that was turned down. That is the certified copy, my lord, would kindly come.
Why your prayer was turned down?
Yes, I'll be my lord, order number 113, 16 June 2025.
Yes.
My lord, in course of hearing, apparently the Assistant Commissioner of Kolkata Police had submitted a compliance report.
Yes.
And that was, my lord, to a great extent against us.
Hmm.
My lord, it was stated that one of the accused persons has not provided his address where he was staying in Kolkata, and the other one has provided an address where he was not staying.
Hmm.
This is the allegation, my lord, and this report is being submitted in the month of June 2025.
Then what wrong in this order?
My lord, would kindly see now the fact remains, my lord. My lord, would kindly come to page 20 of my application once.
Yes. If there is a report against you
Yes.
that you have provided false address,
It is stated
the
one has not
investigating agency.
provided and the second has provided a false.
Yes.
Now, my lord, would kindly come to page 20 of my application, my lord.
Yes.
Page 22, my lord. It is alleged that this petitioner, Mosibur Rahman, has not provided any address. Page 22. Now, my lord would kindly see the date at page 22, 20th March.
Yes, whether your application is sufficient.
My lord, that has been acknowledged that I have not provided. That is a incorrect statement. That Mosaibur has not provided any address.
This is disputed question of fact, na?
Yes, but I am facing the trial.
It is better to go and satisfy the trial court.
My lord, I have. It has
But
been rejected.
before that, kindly peruse page 18 and 19 first.
We are making any statement.
But there is earlier revisional application. First on page 18 is order dated 6th of May 2024. That day has been withdrawn. Like kindly turn the next page, page 19.
Dismissed as not fresh.
Yes,
Kindly
my
turn
lord,
the
why I
next
will
page.
say. my lord,
Matlab
Why I will
9th. 5th of
October.
October 2024.
Yes.
Kindly see the order petitioners paid for relaxation of condition of bail. Same here.
Hmm.
In view of the nature of relief sought for, I am the opinion that revision petition is not maintainable.
Yes, because my lord,
Similar-
why my lord, I will
It
say.
is not
Yes.
maintainable. This order has been not been challenged. Order
No.
still is there.
No, my lord.
Again, same thing has been done.
No, my lord. Because,
On the other hand,
My lord, may I
she has
just
not
state this?
complied the order
my
itself.
lord, may I just say this? These orders, it was not maintainable because directly from the order of bail, I have come to the High Court. Herein, I
What is
have
the
earlier
petition?
made an application before the Sessions Court that has been turned down. Hence, it was considered to be not maintainable because I have directly come up from the order of bail.
Where is the application of that CRR?
Yes, yes. It is not available in the Sathak also. I checked up.
In 2024, my lord.
But where is the application? Application of CRR
And my lord,
3608.
Yes, but I will come back then. my
Nothing
lord.
appears from this order.
and
Yes.
my lord,
Then, my lord, I will come back with the
on the
petition.
merit, my lord is passed on 2022 up to 2025, no communication. Nothing has been made. All is
Hmm.
categorically stated by the trial court. It said not at all complied any order.
It is better to approach trial court.
My lord, I have
Trial
approached.
court make consider your
My lord, they have refused. Hence, I have come, my lord. Trial court has refused.
Refuse with the
No.
specific reason.
reason. You satisfy those reasons. Na?
But-
Trial court
Has
had
refused.
relied upon the report of police commissioner.
Yes.
So you satisfy learned trial court on that score.
He also satisfied here. He communicated to the police. Like order of 2022. Well, he referring in 2025 communication letter.
Limited.
So after 3 years.
It is not that
Well,
it has
it's-
not been.
What is the stage of trial?
But recording of evidence
This is going on. Well, say
I am
UPA,
appearing, my lord, on
How
every
many-
date.
How many witnesses?
UPA act is there, my lord. This is serious offense is there. They may be
How
absconding.
many witnesses has been
My lord,
examined till
my instruction, my lord, 4 or 5 is going on, my lord.
Out of?
and
PW 6 going on. There is
Out of-
40 or 42 witnesses. We will not examine all of the witnesses. 6 already going on, my lord. We, my lord, maybe examine 20 to
so
25.
expedite trial
Trial, yes.
so that the interest of a kid cannot
My
be
lord, my lord.
adversely hampered. Learned advocate for the petitioner prays for relaxation in the condition of bail.
No, my lord, it's challenging the order, my lord. It's not like it's challenging a order which is election of condition of bill.
Condition of bail granted when the bail was granted,
My lord, page 16, my lord, is
16.
14th
14
November.
November
Yeah.
2022.
granted on 14th November 2022 by Chief Judge City Sessions Court, Calcutta, in session case number 15 of 2020.
Challenge.
তো হয়নি তারপর তো হ্যাঁ পুজোর আগে কেটে দিয়েছে সেই
Petitioner approached learned trial court for relaxation in the condition of bail which was refused on the ground that Ruhul Amin had provided false address to the investigating agency and Mosibur Rahman did not furnish his present place of stay to investigating agency as appeared from the report submitted by the Assistant Commissioner of Police, Calcutta. He challenged the said order in this revisional application. A learned advocate for the state
He did not comply with the condition of the relaxation.
vehemently opposed the prayer
पुलिसको জানাইনি দুটো condition
of which condition you
My lord, two condition he did not comply. One, my lord, there are conditions he shall provide the address to the IO. They did not given, and also my lord shall not leave the jurisdiction and intimate the which address they are residing. This is also they will not intimated, my lord.
both conditions were imposed. The accused petitioners depose passport. The accused shall report the investigation once in a week until the and shall not leave the jurisdiction.
বাংলাদেশি ফরেনার
তো অন্য লোক
Provide address where they shall presently reside.
এগুলোই আগে করে জাল নোটে ওইগুলো
Vehemently oppose the prayer of petitioner on the ground. Yeah. Vehemently opposed the prayer of petitioner on two scores. On the score that petitioners, one petitioner or two?
Two petitioners.
Petitioners did not comply the direction of
ওরা বুঝবে বলা আছে মজাটা থাকবে
bail the direction regarding to provide the address where they shall presently reside to the investigating agency as well as this court were not complied for. And what is the other condition?
They shall not leave the jurisdiction of Kolkata. We do not know why they are residing because address is not there.
And they shall not leave, and the condition of they shall not leave the jurisdiction of municipal limits of the city of Calcutta
and one Rahul Amil furnish a address. So we inquired that and it's found that it's a fake address.
Usually it's the same address.
but
Rahul এটা fake, Amilটা দেয়নি। এই
Kolkata,
মতিসুর রহমান সে দেয়নি।
but Mosibur Rahman did not furnish
The reported copy.
his place of stay till now. He further submits that Ruhul Amin furnished false address to the investigating agency.
একজন আছে একজন নেই এখন
Since they did not comply the condition of bail till now, they are not deserved. Yeah, the condition of bail till now, the condition of bail should not be.
Application করো না।
What is your prayer? What is your prayer, sir?
His prayer for his prayer is causing of order, my lord.
Yes.
Wishing for the order.
Of an order,
Yes,
man.
order,
Setting aside of the order so that the condition be relaxed. That is all.
For relaxation of
Yes.
the condition imposed in the order dated 14th November 2020. Learned advocate for the state also referred an order dated 6th May 2024 passed in CRR 1374 of 2024 which was dismissed as not fresh, and the order dated 5th October 2024 passed in CRR number 3608 of 2024, which was disposed of as not maintainable by the coordinate bench. या आगे कोऑर्डिनेट दे देंगे ऑर्डर डेटेड आ तो एंड आ तो आप कोऑर्डिनेट ठीक है परे हम ठीक होता आई विल करेक्ट देम so he prays for dismissal of this revisional application as is not maintainable. Heard the learned advocate and consider on the material available on record. This court do not find any material to interfere in the impugned order. However, petitioners are at liberty to आगे ये लिखो peruse the impugned order wherefrom it appears that learned trial court has rightly rejected the prayer of petitioner on the ground of এই যে আছে Hmm. পেজ নাম্বার নাই, লাস্ট পাতা আছে। তারপরে যে আগে বলেছিলাম সেটা করো। However, petitioners are at liberty to
Liberty is
approach
always
the
there.
trial court.
Liberty is always there, my lord.
একটা
At least I should get this much, my
My
lord.
lord,
A liberty
is
from the
always
High
there.
Court.
Liberty.
And at least I should get this much. A
Liberty is
liberty
always
from the High
ওর
Court.
আগে
Anytime.
একটা আরো দিয়ে দেবে, in submission of
Right, my lord,
state
you can approach.
out of trial is going on and examination of 6 PW out of 40 is concluded, and they assured that trial could be concluded within short span of time.
Some of the accused person pleaded guilty.
Eh?
Some of the accused person pleaded guilty. Some of the accused person. The trial has been
He further submits that some of the accused person has pleaded guilty. তারপরে ও দিয়ে দাও ইয়ে করে is dismissed, is dismissed on merit. Liberty দিয়ে দাও,
Yes. I'm deeply obliged.
liberty to approach the trial court by
And what the High Court reject and
trial court affairs.
Get
You are at
report
the
may be kept on record, my lord. Report may be kept on record. Report filed by the state.
report of
Filed by the state may be kept on record.
which report?
My lord, I already handed over your lordship, my lord.
Yes, একে আগে লিখে দাও। The report submitted by the review for the state is kept, is taken on the record, kept with record.
Get
Yes,
Your Lordship, this is a case
Hmm.
where the petitioner, a trial is going on in the year 2022. Annexure P5 at page 16, Your Lordship.
2022.
18th of November 2022, the
Yes.
petitioner had filed an application under section 311 of CRPC for recalling of the witnesses as because the PW 1, 2 and 3 had made contradictory statements in the during the chief examination in chief
Hmm.
before the trial court.
Hmm.
Curiously enough, this application is still pending without being this application being heard out and disposed by the learned sessions judge at Balurghat. The learned judge had passed an order 11th of September 2025
Yes.
saying that as because the High Court is you have to bring a stay order. Your Lordship, this is the order. It will be to সাহেবকে
Hmm.
এটা আজকের দিন ছিল। Your Lordship, without the disposing of this application under section 311, he is keen to pass an judgment.
Judgment has
Keen
been
to
passed.
pass an judgment without disposing of this application. I filed all the orders, subsequent orders, Your Lordship.
Mhm.
We have communicated that CRR is pending before this honorable court. This application is still not being heard for the recall of the witness. I'm praying for a short stay,
To bring any stay order.
short stay, so that this can be heard out.
Hmm.
The application of 18th of November 2022.
Wherefrom it appears that application under section 311 has not yet been disposed of. By which order?
18th of Annexure P5, page 16.
See.
It shows that the accused person has filed an petition under section 311 on 18th of November 2022. Page 16.
Today's conservation.
Still not disposed of.
Petition under section. Yes, this order was passed on 9th January 2023, and still that application is pending. How can you say? From this order, nothing appears about the pendency of application under section 311. On the other side, the accused person. No, you had filed your application on.
This is 18th of November 2022.
No,
Till
that
date,
that
it is-
application has already been disposed of.
It has not been heard out or disposed of. All the orders, Your Lordship, therefore I have annexed.
You have filed a fresh application on 30th April 2025.
30th.
April 2025.
Your Lordship, page 20 also it says that it is a petition is pending. Page 20 under section.
You come to the order number 74 dated 30th April 2025.
Yes, Your Lordship, the DW there was there, but still that date also it has not
No,
been heard out.
You read out, na? Read out this order loudly.
I find that it is nothing but a dilatory practice adopted by the accused since 2016. I do not find it to allow the petition filed from the side of the accused person. Thus, the same is
No,
considered.
previous paragraph.
The accused person is directed to get ready for argument on next date, failing which the matter will be heard on merit and judgment will be pronounced. 13/6 of 2000.
Previous, you read out from the first sentence.
Pardon, Your Lordship.
First sentence, today is the date fixed for the hearing of argument.
In the second portion. Today is the fixed for appearance of sole accused and hearing of further argument from the side of defense.
No, you are on wrong. Order number 74.
Order number 74, I find that is nothing but a dilatory practice adopted by the accused person in this case, which is pending since 2016. Considering the above situation, I do not find it.
No, you are on wrong order. Ekadin.
Your Lordship, this is the order.
This is the certified copy of order.
এটা চলছে, এটা প্রথম পোর্শনটা বলছেন সাহেব, প্রথম পোর্শনটা।
Yes, read it out.
Your Lordship, on the other side, the accused person files a petition 311 of CRPC with a prayer for adducing evidence from the side of heard both sides. Produce the case. It appears that the record of the case is pending to 2016. The scheduled
Stop.
dates are there.
Stop. On the other side, the accused person files a petition under section 311 of the CRPC. So
But that is the same petition.
this is new application, new petition under section
Your Lordship,
311.
Your Lordship, kindly peruse from Annexure P5, page 16, 17, everywhere it is saying that 311 petition is pending. Page 18 also, Your Lordship, 18/11/2022, 311
It
petition
means
is,
there was 311.
nothing has been.
So this is your burden. You have to bring all relevant
Your Lordship, the 311
document. Otherwise,
is not yet disposed of.
this one, earlier one was disposed of.
No, Your Lordship, page 18 to 20, Your Lordship, all the order speaks of itself. Page 20, 21, the 311 is not yet disposed of.
Now
Again,
you bring certified copy of all orders. Otherwise,
Your Lordship, I'll be bringing in the, Your Lordship, in the meantime, a short stay. Otherwise, this application will become in.
Those orders are necessary for admission of your
Yes, Your Lordship.
original application. Unless the original application be not admitted, how the order?
Your Lordship, otherwise this application will become infractive. If the 300 application is not allowed, Your Lordship, by
No, you did not come with all relevant papers. Petitioner previously filed
18.
an application. Come to paragraph number 4 of your application. Previously filed application under section 311 CRPC on 18th 11/2022.
For record of the witness.
And subsequently you filed
On the, as per Your Lordship, is
on
30th
30th
of,
April 2025.
Your Lordship,
So there are two
two
application.
there. Two cannot be there.
So what you are showing at page number 18, 19,
In 20
that
section
that order was passed in respect of previous one.
the same 300 and application as it falls from Your Lordship.
What
Then
happened
we
to this? This one is not available on record. This is your averment in
Your Lordship,
application.
the LCR can be called for this, Your Lordship,
No, this is
Our-
not a time to call for SCR.
because Your Lordship, the two
At best, you may file certified copy of entire order book.
but Your Lordship, this judgment will be passed in the meantime, Your Lordship, if a short stay is not there.
No, but you may make prayer for the disposal of this 311. Without disposal, order
Your
cannot.
Lordship, then kindly be, without disposal of the 311 application, the
Judgment cannot be passed.
Your Lordship,
If passed, then you might have more.
Your Lordship, the short stay, otherwise we'll be filing all the certified copies of all the orders as per Your Lordship direction.
Without disposal of your application, judgment cannot be passed. If passed, that would be amount of
Your Lordship, then
irregularity,
kindly give a
irregular
direction.
order.
This pendency of this application of the obtaining the certified copies, the judgment may be reserved. Your Lordship, that will
No.
also.
No order can be.
Then
Still,
this
still,
application will become infractious, Your Lordship, then. 311 application.
so in anticipation, no order can be passed. First, you come with proper and
The
sufficient
311
documents.
application, Your Lordship, the disposal, Your Lordship, if Your Lordship kindly pass a direction to that effect, that the 300 application is.
Nothing appears from this order. Whether 311 is still pending or not.
No, nothing is there, Your Lordship. This
Then
is the
it
recent
might
order.
that in between.
Recent order, Your Lordship, and today was the date fixed. 18th of September.
Already DW, evidence of DW has been recorded.
This
Not
abiding by
background
this
to
311 application, not at all entertaining.
no, your petition has been
5,022.
petition has been disposed of.
Your Lordship, the second application, this thing.
Come to the order number 74, dated 30th April
April, Your Lordship,
2025.
that is the.
I find that it is nothing but a dilatory tactics adopted by the accused in this case, which is pending since 2016.
Accused has every
Considering
right
the
to
above
oppose
situation, I do not
recall of
find
witness.
any ground to allow the petition filed from the side of the accused persons already disposed of. No merit in this case. Take down. Learned advocate for the petitioner. Challenge
Will on the ground that is a 2016 application you have disposed of, but not on the 311
Order.
application.
Dated 30th April 2025. Passed by Learned Trial Court in session trial number 34 of 2016. She submits that this case that learned trial judge is proceeded to pass judgment without disposing a petition under section 311 of the CRPC filed by the petitioner on 30th
You're also 18th of
April
November 2020.
2025,
Previously filed on 18th of
but
November.
it appears that said application has already been disposed of by the order number 74 dated 30th April 2025. Please. No. Same day. Same day. Actually. Order number dete. Therefore, this application become infructuous. There is no order as to the cost. The CRR 3263 of 2025 is disposed of.
Dismissed.
Dismissed. Dismissed to করে দিলাম আগে তারপর dispose dismiss করে yes Lord, I am for the Lord, in the present proceeding, Lord, the learned district and session judge has allowed an appeal, Lord, arising out of Lord, the proceeding, that is the husband in a domestic violence case, Lord, the husband filed an application, Lord, the seeking drawing up the proceeding under section 340 of the Code of Criminal Procedure. That was rejected by the learned magistrate, and that order was challenged in the appeal, and the appeal court allowed. Allowed the and
Uh,
upon the order of
no,
Learned.
by setting aside the
Acha.
order passed by the learned magistrate.
Yes.
Lord, what happened here? Lord, the wife filed a proceeding under section 12 of the Domestic Violence Act. Lord, in paragraph in the
Yes.
Lord, wife filed a proceeding under section 12 of the Domestic Violence Act. Lord, when she filed the application for Domestic Violence Act, Lord, she got an appointment, Lord, as an assistant professor of Joypuria College.
Yes.
Lord, in
Suppressed her income.
my lord,
Suppressed her income.
yes, and Lord, she made a statement that she was not getting the salary for few months. She disclosed this fact that she was employed, and subsequently she said in this same paragraph that she was not getting the salary. I am representing the wife here. Lord, in that aspect, Lord, section 23 application was filed for seeking maintenance. Thereafter, Lord, the salary was disbursed. I filed an application for amendment of both the applications. In the meantime, Lord, the husband has filed the proceeding and for drawing up a proceeding under section 340 because I made a wrong statement.
Yes.
And Lord, the learned magistrate dismissed that application and said order was challenged by the husband in a criminal revision before this learned court, before this honorable court, and that was referred to the learned district and session judge for appeal because it is an appealable order. And Lord, the appeal was allowed. Lord, the learned district and session judge erroneously allowed this appeal, Lord, on wrong proposition of law. Lord, here I had no deliberate intention to make any false statement. The moment, Lord, it was came to my knowledge that I was started getting the salary, I made an application for amendment there. I did not, Lord, receive a single paisa, Lord, as a maintenance in pursuance of my application under section 23 of the Domestic and Violence Act. Lord, there is nothing on record to show that this statement made in paragraph 20 and 29 of the application under section 12 of the DV Act is causing any interference with the administration of the justice. That is the main things. There was no any deliberate intention on my part. And Lord, even the evidence has not been taken on record. Before that, Lord, the 340 proceeding has been initiated.
Yes. Take down. Petitioner is represented by learned advocate. Learned counsel for the petitioner submits that the dispute revolves around the factual accuracy, revolves around the factual accuracy of the petitioner's income statement in her original application under the Protection of Women from Domestic Violence Act 2005. The OP number 2, husband's claim of perjury based on documentation obtained through the Right of Information Act suggests a deliberate misrepresentation. The appellate court's decision to reverse the magistrate's order to allow the inquiry under section 340 CRPC implies that it found a prima facie case of an offense against the administration of justice that warrants further investigation. Further investigation. However, the petitioner's counsel, a learned advocate for the petitioner, has raised a significant point that she had applied for an amendment to her petition to correct the statement. Which could suggest a lack of malicious intent. This point, along with the nature of the payments received, requires a closer judicial scrutiny. The question of whether the alleged false statement was material to the case and prejudiced the opposite party is also a relevant consideration. In the light of the above, and to ensure the ends of justice, it is essential to hear our part, and to ensure ends of justice, it is essential to hear all parties and examine the record of the trial court and the appellate court. Therefore, for the reason stated above, I think it proper to admit this case, admit the present revisional application. Petitioner, তারপর ওই direction দিয়ে দাও। Any order of stay?
Lord, the order of stay is required, otherwise, Lord, the
Petitioner is directed to serve notice. Notice wala je থাকে সেটা এক জায়গায় করে রাখুন। Notice upon the opposite party, number 1, the state of West Bengal, through the office of the learned PP, and opposite party number 2, at his postal address through a speed post with AD, and file affidavit of service by the adjourned date. How much time you need?
Lord, within 2 weeks, I shall complete the service.
After 1 week, we will not.
After 1 week, Lord, in coming week, I shall effect the service.
Then this matter will appear after vacation.
Lord, after vacation, but the learned magistrate court will remain, Lord, just after the Puja vacation. Lakshmi Puja.
I am granting you stay.
Yes. After vacation, any day after vacation.
Let this matter appear after 8 weeks from the date of this order. The operation of impugned judgment dated
22nd day of May 2020.
May 22nd, 2025 shall remain stayed till 9 weeks from this day or further order, whichever is earlier. Let this matter appear. But this matter will not appear before this bench. Let this matter appear before the bench having determination after 9 weeks from this day.
Great.
Lordship, for item number 5, I'm led by Mr. Moyuk Mukherjee. My lord, he is not in town. My lord, kindly keeps it in the next week, my lord.
Madam, we could not arrange in this manner. I had requested you to come prepare. If you could not take pen, then I will dismiss it.
Lordship, then Lordship, I will.
You may take pen, na? Why are you dragging this matter?
My lord, if kindly, my lord, sees
If you are not
number 40.
not feeling comfortable today, I may adjourn it for this day. You go and prepare yourself.
Then, I will do it.
Yeah.
My lord, if my lord kindly turns to page
You
number.
are not required to be afraid. Yes, start.
If my lord.
First, I will start the matter.
Yes. But let her start. Na? She is so junior, she is not feeling comfortable.
My lord, if kindly turns to page number 40, that is the 173 application done by the complainant.
Yes.
My lord will find that in the year 2012, my lord, that is 12 years earlier, my lord, some gold dust and nose pin were sold to the accused, that is me. My lord, where an amount of 8,44,000 was the my lord, in page number 41, my lord.
What is this matter?
My lord,
NI Act, NI Act.
no,
No, Lordship, this is an allegation, Lordship, under section 420, 406, Lordship, 341.
Business transaction.
Lordship, civil in nature, Lordship. What happened, Lordship? The petitioner, Lordship, before your Lordship, the petitioner is the husband and petitioner number 2 is the wife. The complaint, as per Lordship, come to the P1, Lordship, the 156.3 application, Lordship, page number 40. Lordship, the allegation is that the petitioner is a small merchant of a raw gold.
Just a minute.
And
let me come to page number 40.
Page number 41, Lordship.
41.
173 4 of BNSS.
Yes, Lordship. Annexure P2, page 40. Therefore, after page 41, Lordship. Lordship, got it?
You filed a complaint to
1. Arun Pal lodge a complaint
SCGM Barakpur against Mr.
Biswajit Shah, the present petitioner number 1 and petitioner number 2 against her.
Who is Arun Pal?
Against his wife.
Who is Arun Pal?
Arun Pal is. I have as per his allegation that they have business transaction, Lordship, regarding the petitioner as the gold jewelry shop and purchase. There is a business transaction regarding the gold, the dust gold and the nose pins. As per this allegation, the transaction made out in the year, Lordship, 2012, and thereafter, Lordship, there is a no continued transaction or nothing, but no unexplained delay, Lordship. No reason, nothing explained that in this complaint that there is a delay. Why the delay? To lodge this complaint, Lordship. In that 2024, he filed this 156 application. Thereafter, magistrate dated for the inquiry and FIR registered, Lordship. Subsequently, no allegation in the transaction made out in the year 2012, Lordship. Nothing explained, but because he can file, Lordship, the money suit, Lordship. But it's totally civil in nature, Lordship. His time, there is time bar in civil money suit, Lordship, 3 years. After his time gone, he gives the criminal color, Lordship, in the year 2012, after the 12 years later, Lordship, and thereafter filed this instant case, Lordship. And at that time, the gold value, he calculated that the 8 lakh, at that time, that amount not a 8 lakh, Lordship, and admittedly 60,000 paid, Lordship.
Admittedly, you have gold jewelry shop.
I have earlier, Lordship. Now, presently, I have no jewelry shop, Lordship.
No jewelry.
Earlier, Lordship.
60,000 paid.
60,000 paid also, there is a part payment also. He admitted that, Lordship, there is a part payment, Lordship. And as per the Delhi Race Club and
What is your
there is
prayer,
a judgment of Lordship that the 420-406 cannot lie together, Lordship, and there is a judgment of the Supreme Court, Lordship, that the police cannot act as a recovery agent. And Lordship, he gives the criminal color, and there is the only motive to recover the money, Lordship. And no, Lordship, nothing explained that why the delay is 12 years, Lordship. No explanation regarding
no
this, Lordship.
explanation for the delay?
Lordship, we are covered by Lalit Chaturvedi and Delhi Race Club. Milord, furthermore, if Milord goes into the complaint also, there is no evidence or no material fact of 126(2) of BNSS and 115(2).
That he already submitted.
Lordship,
406
thereafter,
and
Lordship, 41
420.
notice, Lordship, issued, Lordship. I got surrender and got bail, Lordship. They filed the cancellation application. That application rejected, Lordship. There is a delay is 12 years, Lordship, but nothing explained, Lordship.
Yes,
And part
take down,
payment is
take
also there, Lordship. I am paying for stay, Lordship. Stay the proceeding, Lordship.
What is the stage of proceeding?
The FIR, Lordship, the FIR stage, I filed this application, Lordship.
Eh?
FIR stage, I challenge the FIR. In that proceeding, FIR stage, Lordship.
So investigation is not going.
It is going on, Lordship.
So what you pray?
I am paying for stay of the entire proceeding.
Stay
And
of investigation as well.
Lordship, you are causing up the proceeding, Lordship.
Question. The question
As
of
per-
question
as
will
well as
come
per- as-
after admission.
As per my instruction, Lordship,
Today
we don't know.
today is for admission hearing.
I am praying for stay of the proceedings.
Stay of what?
Proceedings, Lordship.
Proceeding
Before the
means
landed court below,
landed court below.
Lordship.
Proceeding
No. Entire proceeding.
does not include the proceeding of investigation.
As per my
That's why
instruction,
I am
Lordship, as per my
I am
instruction,
making you
charge is
aware.
submitted, but charge 207 copy not
Investigation
delivered.
will continue.
Lordship,
Then what proceeding is pending before the court?
the framing of charge, or Lordship.
Without completion of investigation? How?
Lordship,
charge
as per
can
my
be-
instruction, Lordship, charge sheet submitted, but copy not served.
You do not have proper investigation information, sir.
Lordship, I am praying for only for the stay of the proceeding.
At the one hand, you are submitting that investigation is going on. On the other hand, you are submitting that charge sheet has been submitted. How both can be possible? Take proper instruction. Otherwise, if you feel comfortable, then I am shifting it for tomorrow. Take proper instruction, then we'll pass order. Okay, call karo.
Lordship, give me 5 minutes.
On the
10
prayer
minutes
of-
pass over, Lordship.
Not 5 minutes, sir. Many other matters are here.
Then give it on.
However, you may try your luck. If I would be in position to take this matter again, then you may move. Then I am passing it over. और मैं एमनी आपने लिखे रखो on the prayer of learned advocate for the petitioner. Let this matter. It is better to come tomorrow. Let this matter appear tomorrow. Learned advocate for the petitioner is directed to come with proper instruction.
See, if possible, Lordship, kindly keep it on Monday, Lordship, if possible.
No, sir. First, this is not a regular bench.
Careful, Lordship.
So we cannot.
Lordship, for 6th time for the petitioner. It's
Yes.
Dicham.
Give your appearance.
Yes, Lordship.
ये যারা অপিয়ার মুভ হচ্ছে ওদেরকেই নাম দেবে একটা দেখেছিলাম অত বড় চিঠা দিয়ে দিয়েছে না একজন মুভ করছে একজন দাঁড়িয়ে থাকছে দাঁড়িয়ে থাকলে হবে না Yes. Yes, what is in this matter?
Lordship, similar,
Same party, same matter.
not same party, my lord. This is with regarding to a plot of land. My lord, here also, my lord, 42406 is the sections which are involved. My lord, if kindly sees, my lord, it's a civil matter. It's totally a civil dispute. No preliminary inquiry was conducted when the alleged offense, my lord, the alleged offense is of 2022 and 2023 between, and the FIR was registered in the year 2024. My lord, no explanation for the delay. No notice under section 35(3).
How much
served.
delay of? How
Delay
much day?
of a year, my lord, a year or two. 2022 to 2023, the alleged offense has taken place. And my lord, in the year 2024, September 26th, the FIR was registered.
Yes.
My lord, no notice under section 35(3) was served to the petitioner. Money suit has been filed against the petitioner on 23rd.
Why the transaction was made? Transaction?
My lord, if your lordship kindly allows me, I'll just factually brief your lordship. Your lordship, the petitioners of your lordship are the registered owners of plots of land being RS Dag number 1277 and 1280. If your lordship kindly turns to page number 31, there we have annexed the registered deeds of conveyance through which we have purchased two plots of land. Now, your lordship, what has happened is that after we purchased the plots of land, we have applied for certified copy of the parcha from the BLRO department, Rajarhat, in page number 105. In page number 105, if your lordship kindly sees, I'll be very short and yeah, in 105, the lordship kindly sees the bottom right side of the parcha. It's totally showing that, certified to be true copy from the registered BLRO department, Rajarhat. Now, your lordship, what has happened is that the opposite parties, the other third parties who approached us to buy a plot of land. Now, after conducting the valid search, valid title deeds, everything, they were satisfied. They have paid an advance amount. And after paying an advance amount, they had promised that they will complete the entire sale procedure within 1 month. Now, not only 1 month, your lordship, 6 months happened, 1 year happened. We kept on sending them.
They did not proceed.
Yes, absolutely, your lordship.
Yes.
They did not proceed. Now, your lordship, we have also annexed all the correspondences showing the bona fideness of our clients in page number 106. We kept on sending the reminders. If look, these are the advance payments you have done. If you do not complete the sale procedure within such and such time, the entire amount will be forfeited, and thereafter you will be having a separate call before separate forum. And they did not even reply. They did not choose to meet us or to sit for in any kind of discussion whether they are purchasing the plots of land or not. Now, your lordship, what has arisen before your lordship is that suddenly we receive a legal notice. After receiving a legal notice, they send us, if your lordship will kindly take the trouble to page number 117. In 117, your lordship, no human eye can read these certified copies of the deeds. They are stating that these deeds were already sold to someone else, whereas your lordship, we are the registered owners of the said plots of land, and we have always complied with the relevant search reports, relevant documents, and suddenly, just to extort money from us.
You are owner of that land.
Absolutely, your lordship. We are owners of that land. And even your lordship, till date, we are still in possession of that land. And thereafter, when the criminal case was instituted, the BLRO office had sent us a notice. We had complied with that as well by stating that, look, we are the owners of the land. Just before your lordship, as we have annexed all the documents, we have also annexed all the documents to them.
Yes.
Now, they are completely clueless how this has taken place. We are the owners of land. Now, they are sending some title deeds pertaining to some other property and claiming it to be the title deeds of RS Dagna.
It is better to go for civil suit, title suit.
Exactly, that's
Would
the
give you
absolutely, your lordship. I'm grateful that your lordship is having such a view. They should have approached
there is
before the
dispute on the title of any land.
absolutely, your lordship.
That decided by civil court.
That was our initial, but they chose to approach the criminal courts. They thought that's why they approached the money suit, the civil courts, by filing a money suit. They did not apply for a proper suit for
What is the allegation of OP number 2
OP number 2, your lordship.
in civil, in criminal case, FIR?
FIR, your lordship, if your lordship will kindly allow me, OP number 2 is claiming that he is a third party who came to us to make the talks of purchasing the land. He is claiming that we have given them false documents and we have cheated them, which is absolutely false. Whatever documents we had, we have annexed before your lordship in annexure P2, the certified.
Whether any agreement was executed in between OP number 2 and you?
No, your lordship, no agreement was executed.
No agreement.
But by virtue of your lordship correspondence, when I was
With OP number 2?
yes, your lordship, OP number 2 correspondence were there, written correspondence in page number 106, annexure P3. And your lordship will kindly allow me to place this submission with your lordship. Like when I was college, this professor has taught us that, as per Indian Contract Act, whenever there is an offer and acceptance, it demands, it totally states an implied consent and valid consent as well. So they were always communicating with us.
Yeah, stuck down. The petitioners, Mr. Karthik Saw and Shikha Saw, have preferred this criminal revision for quashing of proceeding in connection with Razarhat Police Station case number 382 of 2024, dated 26 September 2024, started under section 316 bracket 2 oblique 318 bracket 4 oblique 336 bracket 2 of BNS 2023 and GR case number 3820 of 2024, now pending before the landed Chief Judicial Magistrate at Barasa. The petitioners are senior citizens who have been arraigned as accused in the aforementioned case, which involved allegations Learned counsel for the petitioner has submitted that the entire criminal proceeding is a blatant abuse of the process of law. It is contended that the dispute is fundamentally civil in nature. Stemming from a failed land transaction between the parties. The opposite party number 2, the de facto complainant, having failed to complete the sale despite receiving a significant time, is now attempting to misuse the criminal justice system to recover the forfeited advance money. This contention is strengthened by the fact that a separate money suit being MS
500.
number 500 of 2025 has already been money suit is filed.
Yes, Your Lordship. They have filed a money suit.
Where is the
Your Lordship, I have annexed
page number?
page number, Your Lordship, 185. 183, 185. In 185 is the notice, and 186 is the title cost settle. Mehbubuddin.
500 of 2025 has already been filed by the OP number 2 in the civil court at Barasat for the very same cause of action the simultaneous pursuit of civil and criminal remedies for a common grievance suggests a mala fide intention to harass the petitioner. Furthermore, it has been highlighted that there are significant procedural lapses in the initiation of the criminal case. The FIR was lodged on 26 September 2024, more than a year after the alleged commission of the offense, which was occurred between 2022 and 7 January 2023, with no reasonable explanation for the delay. The petitioner, the learned advocate for the petitioner, also submits a petitioner submitter that the police authorities failed to conduct a preliminary inquiry as mandated by the Honorable Apex Court. Before registering the FIR. In view of the above submissions made and the apparent civil nature of the dispute, coupled with the alleged procedural irregularities, I am of the considered opinion that the matter warrants a detailed examination. Therefore, the application is admitted for hearing. Let the petitioner serve notice along with a copy of this revisional application to OP number 1, the state of West Bengal, through the office of learned PP, and OP number 2 at his postal address through a speed post with AD . An affidavit of service shall be filed by the next date of hearing. Let this matter appear after 8 weeks from this day before the bench having determination. Admit.
Your Lord, stay. I was just praying for a stay because investigation.
Prayer is there.
Yes, sir.
Prayer for stay is there.
Yes, Your Lord.
What you want to
The issue is that Your
stay
Lordship.
of the proceeding?
Yes, Your Lordship.
Stay of what?
The proceedings, Your Lordship. The issue is
Proceedings
that
of
for the petitioners, Your Lordship. The issue is that the
what
matter is,
proceeding is going on?
Your Lordship, the investigation is going on, and since we have already,
So investigation cannot be stayed.
Your Lordship, then just one humble direction that no coercive steps can be taken against the accused.
That good.
Pending investigation, if Your Lordship kindly desires.
Learned advocate for the petitioner prays for a direction to the investigating agency that no coercive step should be taken against the petitioner. The direction, the prayer is allowed.
Gratefully.
Investigating agency is directed to not to take any coercive action against the petitioners without any patent, any order of the court of competent jurisdiction.
I'm grateful, Lord. My Lord, no process till the next.
This order will remain in force till the adjourned date.
Till adjourned date.
Yes.
Appearance. 8
Item number 7.
till 8 weeks.
With the appeal of name of the petitioner.
Gratefully, Lordship.
My lord, I am paying for quashing of a proceeding such and such. Case is under section 348, 320, 3506 of IPC, my lord. All are magistrate tribal section, my lord. The petitioner before your lordship is an
What is your prayer, sir?
quashing of a proceedings, my lord. Justice already submitted, my lord. The petitioner before your lordship is an joint register of university.
What
and
is the
complainant is a student, my lord. My lord, kindly come to page number 14, my lord, the letter of complaint, my lord.
page number?
14. The alleged allegation against the petitioner, my lord, married. Page number 14, para 3, my lord.
Complaint against Tanmay Majumdar.
I, along with 4 other students of my mess, where are also the student of my college, RERF, went to the SVU to find Sudipto. On reaching SVU, we found that Sudipto was kept confined in
What is SVU?
Swami Vivekananda University, my
Okay.
lord.
Yeah.
Kept confined in room number 103, and the room was being guarded by some staff of the SVU. On seeing us, we are told by the staff member SVU to go outside the building. Obeying their instruction, we immediately went to outside the SVU building. While we are moving out, some staff of member of SVU called us and asked why we had come to SVU building. We replied to them that we have come to find our mess partner Sudipto Hajra, who is student of SVU. On listening to our reply, one of the staff member alleged that we have come intoxicated condition. We have also made our mess partner Sudipto intoxicated. and sent him to SVU. But as far I know, Sudipto on that date had come to SVU directly from his place of residence. The staff and the member of SVU asked us why the written our name, phone number, guardian's name, and the phone number on the sheet of the paper. We did so as per their instruction. Thereafter, one of the staff member asked other student who had come along with me to go outside of the SVU building. However, he asked me to come inside the SVU building.
Hmm.
To my next page, my lord.
Yes, sir.
To my surprise and amaze, one of the staff members started doing video recording in his phone, and he asked me name of the address, etc. I answered all the questions. The staff member then started hurling alleged that I supply marijuana and alcohol inside of the SVU building. This time I denied the allegation. I was taken into the room number 103 where the Sudipto was initially kept confined. They gave me a piece of paper and pressurized me right that I had come to SVU in intoxicated condition. When I refused in writing the falsely alleged allegation which were being laid against me, again I one Tanmoy Mojumdar, that is my lord petitioner hearing, switch on his camera recording the allegation that I have stolen lab equipment of the SVU. I once again vehemently and forcibly denied the false allegation. Then I was beaten badly, my head and neck by Mr. Tanmoy Mojumdar. Then I asked me to leave the SVU. The allegation against the petitioner is level based, my lord. All are false and frivolous. My lord, kindly come to page 46, the injury report, my lord. এখানে তাপ পড়া ছিল কোথায়? My lord, in the bottom portion, in the column number 7, my lord.
No, beaten badly.
Yes. My lord, column number 7, my lord. The
Page number?
Page number, my lord. Just a minute. My lord, page number 46, my lord. Annexure P4. Kindly come to column number 7, my lord. The incident occurred at 7 p.m., my lord, and came to the hospital 11:15. 3 hours.
Wait a minute, just a minute. Let me come to that. Very good. 4, 45, 46. Yes. Could not be asserted. Information regarding
The
occurrence.
incident took place at 7 p.m. on 10 May 2020 and came for treatment in the hospital 11:15 on that next day, my lord. 11:15 a.m.
But date is same.
Date is same, but 11:15 a.m. my lord. Next. And
No, it may be. It may be a mistake. I mistake it.
Would not be asserted by me.
Yes.
But he is
Assault by terminal
yes, assaulted
patient cannot say and for others beaten with fist and slap.
yes, but
What injury a person may get by assaulting fist and blow? Yes.
false allegation. All
Yes. This is not it.
161 statement by two guard. All are the hearsay statements.
Page number?
Come to page 26.
Yes.
Alert.
Yes.
ঠিক তার 30 থেকে 40 মিনিট পর এক এক করে সেই ছেলেগুলো বেরিয়ে চলে যায় কোনো কিছু না বলে। ওই দিন রাত 8টা নাগাদ শান্তনু ঘন্টা নামে এক ছেলে গেট থেকে বেরিয়ে আসে। আমাদেরকে গেটে বলে যে স্বামী বিবেকানন্দ ইউনিভার্সিটি তন্ময় মজুমদার শান্তনুকে মারধর করেছে, ফলে শান্তনু আঘাত পায়। তখন তাকে আমরা বলি হাসপাতালে চিকিৎসা করানোর জন্য। My lord, only stated by the
He was sick, Sanwar Ali.
Yes. He was security guard, my lord, in that university.
Where he was
The incident
at the
stated-
time of
the incident stated by my lord, the de facto complaint.
yes.
He was not the eyewitness. My lord, next come to the page number 27. My lord, para 7 mark. ঠিক তার 30 থেকে 40 মিনিট পর এক এক করে সেইগুলো ছেলেগুলি বেরিয়ে চলে যায় কোনো কিছু না বলে। ওই দিন রাত 8টা নাগাদ শান্তনু ঘন্টা এক একটা গেটে বেরিয়ে আসে। আমাদেরকে গেটে বলে স্বামী বিবেকানন্দ ইউনিভার্সিটি তন্ময় মজুমদার শান্তনুকে মারধর করে, ফলে শান্তনু আঘাত পায়।
Hearsay.
All are the hearsay evidence. Nothing
Yes.
evidence of eyewitness. Now,
What is the stage of investigation? Trial.
File,
What is the stage of trial? Charge framed.
not yet. Only charge sheet filed and 207 copies have handed over, my lord.
Then go and face trial.
Sir, I am submitting
When the charge sheet was filed.
my lord on 23 December 2022, mark.
And it,
I'm relying upon the parent 80 mark. Judgment mark.
for
For washing of the proceedings mark.
what is said in this judgment?
Kindly come to para 18 mark.
Yes, I am here.
Summoning of an accused in a criminal case, my lord, accused in a criminal case in a serious matter, criminal law cannot be set into motion as the matter is court. It is not that the criminal complaint has bring only two witnesses to support his allegation in the complaint to have the criminal law set out in motion. The order of the magistrate summoning the accused person must reflect that he has applied his mind to the fact of this case and law applicable thereto.
The court has already applied his mind and cognizance has already been taken.
Yes, my lord. I am also relying.
Now, this matter is the
I am relying on
disputed question of fact. Allegation is that you have assaulted, and your stand is that you didn't. So let such question be decided by the trial court after recording their evidence.
kindly come to para of judgment, my lord.
Don't show judgment at this stage, sir. Don't show judgment. I am not hearing you on merit.
Then, my lord, I am seeking.
This is admission hearing.
My lord,
Prima facie material is sufficient to either admit or to dismiss.
I am seeking to stay in proceedings.
First, let me admit. Without admitting, if your application be dismissed, then this is admission hearing at motion stage. You are at motion stage. Don't file any judgment at this stage. Yes, take down. This is an application filed under section 482 of the CRPC. Read with section 528 of BNSS for quashing of the proceedings quashing of the charge sheet being 108 of 2022 dated 26th December 2022 under section 348, 323, 506 of the IPC 1860 arising out of the FIR being Mohanpur Police Station case number 20 of 2022 dated 7th June 2022 pending before learned ACJM at Barakpur. The petitioner Tanmay Majumdar has been arraigned as an accused under section 3. The learned counsel for the petitioner submits that the proceeding against the petitioners, only act of petitioner, not petitioners, petitioner, a gross abuse of the process of law. It is contended that the allegations in the FIR are baseless and the petitioner has been falsely implicated in this case. The petitioner is a deputy registrar at Swami Vivekananda University. He has a clean reputation and no prior criminal antecedent. Learned counsel has further submitted that the statements of witnesses where is witness at page number 26 and 27 recorded under section 161 of the CRPC do not support the allegations made against the petitioner. He also referred the injury report of the de facto complainant annexed at page 46 of this application, which highlighted wherein the nature of injury was not stated in wherein it has been mentioned in the column of nature of injury that it could not be ascertained could not be ascertained it could not be ascertained. He also pointed out the wrong description in date and time of information regarding the occurrence, date and time, we have wrong mistake in that date and time in column number 7 and 8 of the said injury report. Which, as per the learned counsel, raising doubts about the veracity of the allegation of assault. He further submitted that there is a significant delay in seeking medical attention. On these grounds, it is argued that the continuation of the proceeding would be an exercise in futility and a travesty of justice. Upon hearing the argument and pursuing the materials on record, including the FIR and charge sheet, and the submission made by learned advocate for the petitioner, this court finds that the matter requires further scrutiny. The contention raised by the petitioner regarding the lack of specific evidence, the nature of injury report, and the alleged contradiction in the witness statements are prima facie ground for a detailed examination. Therefore, the instant revisional application be admitted then learned advocate for the petitioner is directed to serve a notice along with a copy of this revisional application to the OP number 1, the state of West Bengal through the office of the learned TP, and OP number 2 at his postal address through a speed post with AD, and file affidavit of service by the adjourned date. Let this matter appear after 8 weeks stay of which proceeding before. What is the stage of proceeding?
Charge is already submitted. 207 paper is handed over. That is approved.
Then no proceeding has yet been started before the trial court. So charge will be framed. No. Framing of charge will not prejudice your interest. And by then court will reopen, and you may agitate your question.
Day before court period during the puja vacation. That's what is that.
From 2022 till 2025, nothing has been done, and within 1 month, everything could be completed. No stay is required in this matter. No proceeding has yet been started. Only charge sheet has been filed and 207 copy has been supplied to you. That's all.
Next day before court below my lord for
When is the next date?
next day I have to take instruction.
In the year of 2026.
Yes, 25 21/11/2021. The month of November.
Prior to that, your matter will appear and make sufficient before that. No proceeding is there.
My lord, I have received the 207 proceedings. After that, I filed it watching application.
No, sir, no. No such order could be granted. Yes. 8 weeks from the date before the bench having determination to hear this matter. Yes.
Item number 8.
For the petitioner.
Yeah.
But in this matter, I have filed this application for setting aside of the order dated 19th of February 2025, whereby the prayer for modification of the bail, a certain portion of the bail condition has been turned down. Background of the case is that initially a case was started against the petitioners under section 354B, 325, 307 and 379 of the Indian Penal Code. Well, thereafter, the
Setting aside of order.
Well,
Setting aside of order dated 19th February 2000.
yes, ma'am.
What is in this order?
My lord, on that prayer, what we prayed for, the petitions were granted anticipatory bail by an order dated 5th of September 2024, P1, page 15 of my application. My lord, with condition that we
P1, just a minute, let me come to this.
page 15, my lord.
Page 15.
Yes, my lord.
This is the impugned order.
No, impugned order is the last page, my lord. Impugned
Yes.
is ordered.
Why you are referring this order?
Well, I am referring this order because in the anticipatory bail application, the petitioners were directed to surrender before the court below within 2 weeks. Well, the petitioners failed to comply that because the petitioner's mother were suffering from carcinoma. Due to their mother's treatment, they were outside. For that reason, they failed to surrender. Thereafter, their treatment was going on, and her mother ultimately died in December 2024. Thereafter, after a lapse of 5.5 months, they appeared before the jurisdictional court for surrender. And jurisdictional court denied to accept the same because within the time they failed to appear. Thereafter, considering the same, they preferred a modification application before the learned sessions judge Hooghly, from where the anticipatory bail was granted. But that modification prayer has been turned down.
Then what wrong in this order?
My lord,
What wrong in this order?
My lord,
You did not comply.
Yes, my lord, but there are certain because their mother was suffering for carcinoma.
Regular,
it has been stated in the kindly.
Nothing appeared from this order that your mother was sick and admitted in.
Kindly,
Nothing reflected in this order.
Well, the learned, may I read out the portion, my lord?
Yes.
But the learned advocate has submitted that for unavoidable circumstances due to their mother's cancer, the petitioners could not avail of the.
This is your submission.
Yes, my lord. And for that,
did you submit any paper in respect of?
Yes, my lord. As per my instruction,
nothing appears from this order.
This is yes, my lord. From this,
no reflection of any such document.
Reflection is not here, but they submitted the papers. Even if your lordship so directs, I can produce the papers before your lordship also.
Mere submission is not sufficient, no?
My lord, as per my instruction,
I do not find any irregularity in this order.
My lord,
order is perfect.
My lord, they not only submitted, they also has submitted the papers before the concerned court, but maybe it has not been stated in the.
This order has been passed in open court in presence of both sides.
Yes, my lord, that I can.
Then how can you deny that you have submitted and learned judge did not reflect?
No, that I'm not saying, but because it is true that
reflection should be here, no?
But out of only on humanitarian ground, my lord.
No humanitarian ground in law, sir.
My lord, their mother was suffering from cancer.
It is better you go and make a fresh.
Well, lord, once they have anticipatory bail has been allowed, they cannot file another application, my lord.
No, for modification.
For modification, my lord, they had applied. That has been turned down. That is challenging that order. I have filed this
then are you barred to make fresh application there?
No, my lord.
There is no bar in law.
Well, in that case, then your lordship may kindly give some liberty so that with that liberty.
No liberty is required. You go.
Otherwise,
this application is not maintainable at this moment.
In that case, then please kindly give me liberty to file the medical papers before the lordship.
Liberty is always with you.
Okay, then my lord, kindly fix another date. I will file supplementary affidavit with the medical documents.
No, if you go and make prayer before the learned trial court, who has granted you bail.
Yes, madam.
And After perusing your documents or related documents, if he refused your prayer, then you knock the door of this court.
My lord, my humble
This is premature, sir.
My lord, I am bow down to whatever for your lordship, but my lord, my humble submission is the petitioner's prayed for modification of the same order before the sessions judge. With all the documents.
Session judge has rightly rejected. No irregularities, no illegality is in this order. What is the jurisdiction of revisional court? You challenge any order only against the illegality, irregularity in the order.
Yes,
At the face of this order, no illegality or irregularity is appears. Then what should what the direction should be passed?
Well, only modification part so that the
he rightly stated that you did not comply the order of 2 weeks. You only pray that your mother was sick,
suffering from cancer.
This is your submission. You did not file any document in support of your submission.
My lord,
your submission was turned down by the London trial court.
Yes, my lord, that is true. My submission.
Then how can you say that he turned down your submission?
Because my lord, I don't know whether that petitioner is not that petition copy of the petition is not with me. It is true, but I believe they have annexed those documents, my lord. Otherwise, they are
whatever it may be, but nothing appears from this order.
Is not speaking that this is true. But then kindly gives me some liberty to.
No, it is better to dismiss it and you go and make a prayer before the learned court below, a phrase for modification, and thereafter this court is always open for
you. Only give me one liberty, my lord. Otherwise, the court below may refuse.
What liberty you want?
So that I can approach the learned sessions once again.
Take down.
Kindly give me that liberty.
Learned advocate for the petitioner. Challenge the order dated 19 February 2025, whereby his prayer for modification in condition of the bail granted by order number 3 dated 5th September 2024, wherein petitioners were directed to surrender before the court below within 2 weeks from the date of said order, but they did not comply the said direction and approached learned session judge Hooghly for modification in said condition. It appears from the impugned order that petitioners, one petitioner or
3 petitioners
sought modification on the ground of the illness of their mother
Mother of petition number 1 and 3 and wife of petitioner number 2.
How many petitioners? is
3
there?
petitioners are before
Three.
your lordship.
Mother of petitioner number 1 and 3 and wife of petitioner number 2 who was suffering from cancer, but they did not submit any supporting document they did not allocate. Nothing appears from the learned trial court rejected his prayer without his prayer, their prayer. However, petitioners, learned advocate for the petitioner না একে দেখানি কিছু শেষ করে দিচ্ছি nothing, I do not find any irregularity, illegality, impropriety in the impugned order to interfere. However, learned petitioners are at liberty to make a fresh application before the learned session judge Hooghly. Accordingly, this application is dismissed as dismissed on merit, dismissed as dismissed due to devoid of merit. There is no order as to the cost. Yes.
Obliged.
My lord, for item number 9, I am for the petitioner. This is this
Yes.
instant petition is for the expeditious disposal arising out of Barrackpur Women PS case number 34 of 22. Dated
Disposal of what?
expeditious disposal
Disposal
of the instant case Barrackpur PS case number 34 of 22.
This is PS case.
Barrackpur.
Yes. Where your case is pending?
It is pending right now before the learned first JM Barrackpur court.
What is the stage of your case?
Only the copy to the accused has been served, and it is still the trial has yet not commenced. My lord, kindly comes to.
Charge has not yet been framed. Charge framed? Charge framed?
No, no. My lord, kindly comes to page number 12, the last page, and thereafter the page number 13. My lord will see page number 12 is the affidavit, and the last page, the charge sheet. Thereafter, the charge sheet. My lord will see the charge sheet is filed. FIR is lodged on 18/6/2022, and the charge sheet is filed on 28/9/2022. And the accused, thereafter, the accused are on bail. I beseech my lord kindly comes to this certified copy of order dated 17/9/24.
Why the charge could not be framed till now?
That is why I am before your lordship.
Whether you were in
No, I am for the
attendance on each and every day?
no, I am for the de facto complainant. In this matter, I am not the accused. I am the de facto complainant. Here, de facto complainant is a widow of a soldier, and after the death of her husband, she was thrown out of the matrimonial house. When she goes to her matrimonial house,
Yes.
she was brutally beaten.
Yes, take down. The petitioner Papia Mahanta, who is the de facto complainant in the Barakpur police station case number 34 of 2020.
My lord, Barakpur women police.
Women police, yes, women police station case number 34 of 2022 has moved this revisional application. The case involving offences under section 323, 341, 354, 499 and 34 of the Indian Penal Code is pending before learned Judicial Magistrate First Court at Barakpur. Learned counsel for the petitioner submits that despite the charge sheet has been submitted on when the charge sheet was submitted?
Charge sheet dated 28/9/2020.
On 28 September 2022. The case has been delayed for no charge has been framed.
Charge sheet. Charge.
When is the date fixed before the learned trial court?
It is on 9/12/2026.
9/12/2026.
Previously.
For what?
It is not mentioned, my lord. My lord, I have annexed the order dated 17/9/24.
Where is the said order?
On that particular day, it was transferred to
Now,
the.
where is the said order? Did you annex?
Yes, it is in the certified copy, my lord. The last order of the certified copy.
No, this is not the order. This is the FIR 17/9/24.
24. Thereafter, it was fixed on.
Well, let the case record be transferred to the JM. By this order, your case record has been transferred to the JM. Let the case record be transferred to the JM first for disposal.
And next date was fixed on 24th March.
Cognizance is taken. Yes. The case has been listed for hearing on an inordinately distant date, December 9, 2026. This delay is a gross denial of justice and a violation of the petitioner's fundamental right to a speedy trial as granted under Article 21 of the Constitution of India. The Council has emphasized that such a prolonged pendency causes immense hardship and frustrates the very purpose of a criminal trial. Upon a careful consideration of the facts on record, and the submissions made, this court finds merit in the petitioner's grievance. An unreasonable delay in the trial process undermines public confidence in the judicial process and is contrary to the well-established principles of criminal jurisprudence. Accordingly, in the interest of justice, this revisional application is allowed. The learned judicial magistrate, First Court at Barakpur, is hereby directed to take all necessary steps to ensure the expeditious disposal of Barakpur Women Police Station case number 34 of 2022, corresponding to GR case number 5683 of 2022. The learned magistrate shall take up the matter on a priority basis, fix an early date for the commencement of the trial, and make every endeavor to conclude the proceeding as early as possible. A copy of this order copy of this order shall be provided. Accordingly, the revisional application is disposed of. There is no order as to the cost. Item number? Just wait, sir. Yes, yes. Call the list.
I beg to appear for the petition. This is my lord application for quashing of the trustee, my lord, proceeding. My lord, the case is that, my lord, the complaint is a lady of, my lord, married lady of 32 years, my lord, having 2 children. My lord, she is staying in her parents' house. My lord, the petition, she is staying in his parents' house, leaving his husband. And my lord, the complaint is, my lord, page 13 starts, my lord. My lord, this is a 156 proceeding, my lord. What happened, my lord?
What is your relation with OP number 2?
My lord, I have OP number 2, my lord, I have no relation, my lord. I am a co-villagers.
Co-villagers.
Yes, my lord. What happened, my lord? She is staying in his parents' house with 2 children, living her husband. Thereafter, my lord, we met with each other by telephones. Thereafter, my lord, one day it is alleged that I called him in a bazaar with her children. She came there, and from there I took her in a car, and thereafter, my lord, I took her in a
in a certain place for 2 months. Thereafter, she came back home after 2 months and lodged this 156(3) against me, alleging, my lord, the offense under section 376.
These are her allegation against you.
Yes, my lord.
These are her allegation
Yes,
against
yes,
you.
yes.
Hmm.
My lord, kindly see, my lord, after 2 months, my lord, this 156 was filed. My lord, kindly see the, my lord, I have got the 207 papers, my lord. And my lord, kindly see, my lord, the 164 statement I have annexed. There, my lord, he has not stated anything. She has stated, my lord, page 23. May I read?
Yes, page 26.
23, my lord, 23.
23.
This is the, my lord, penultimate portion, my lord. আমি আমার বাবার বাড়ি গিয়েছিলাম বিগত 6/10/2020 তারিখে। হঠাৎ বাবু শেখ, দ্যাট ইজ দ্য পিটিশনার মাই লর্ড, আমাকে বাস স্ট্যান্ডে ডেকে ওর দিদির বাড়ি নিয়ে গিয়ে মাই লর্ড কমিটেড রেপ আপন মি। বাবু শেখের সাথে আমার ফোনে কথা হতো, আমি বাবার সাথে যোগাযোগ করে বাবার বাড়ি ফিরে আসি, এইটুকুই বলতে চাই। But in the FIR, my lord, in the 156(3), my lord, they have stated that he went with me with her children. He went to the bazaars. From there, my lord, totally contradictory, my lord. And my lord, this is false case is filed against me, my lord. So that kindly consider this, my lord.
Who lodged a written complaint against you?
My lord, complaint, my lord, kindly see page 30.
Victim guard.
Yes, my lord.
Victim guard lodged complaint against you.
Well, this is not, kindly see, my lord, this is a married lady, a mature lady, my lord, 2 children, and my lord, he with her own consent come to me. He was not satisfied with her husband, again come to me after staying 2 months. He come back home and lodge this complaint, my lord. Well, kindly see this. It is not bar under 90. It is not the consent by coerce or, my lord, fear.
Yes. What is the stage of
My lord, charge sheet submitted, my lord, and
when the charge sheet was submitted?
in 21, my lord, March 2021. Totally false allegation, my lord. Kindly consider this, my lord.
Charge sheet submitted.
Yes, my lord.
207 complied.
Yes, yes.
Complied.
Yes, my lord.
Charge framed.
No, my lord, charge not framed.
Yes. Take down. Learned counsel for the petitioner, Yad Sheikh, YEAD, Yad Sheikh, alias Babu, raised for quashing of the charge sheet number 93 of 2021, dated 25th March 2021, under section 376 of the IPC 1860, arising out of Bardhaman PS case number 30 of 2021, dated 24th January 2021, and GR number 149 of 2021. Presently pending before which court?
Before ACJM Kandi, Murshidabad.
Before Additional Chief Judicial Magistrate Kandi at Murshidabad, District Murshidabad. A learned advocate for the petitioner submit that the entire prosecution case is false and and an abuse of the process of law. He has drawn attention of this court to several critical facts which he argues vitiate the proceedings. These include a significant and unexplained delay of over 2 months in lodging the complaint. Further, he highlighted contradictions in the statement of the complainant and her father, particularly concerning their prior relationship with the petitioner. A learned counsel also stressed that the complainant, being a major and a mother of 2 children, is said to have voluntarily accompanied the petitioners with her children, an act which stands in stark contrast to the allegation of force. Finally, it has been submitted that the complainant's statement under section 164 of the CRPC is materially inconsistent with the initial FIR and that she has refused a medical examination, a crucial piece of evidence in cases of this nature. On a prima facie examination of the submission made by the material on record, this court finds that the contentions raised are not without substance. The inconsistencies and contradictions in the prosecution's case appear to be of a grave nature, casting serious doubt on the veracity of the allegations. To permit the accordingly, I am of the view that this case, this is a fit case for admission. Let the application be admitted. Learned advocate for the petitioner is directed to serve copy of this revisional application to the OP number 1, the state of West Bengal, through the office of the learned PP, and OP number 2 at her postal address to speed post with AD and file affidavit of service by the adjourned date. Let this matter appear after 8 weeks from this date before the learned, before the bench, having proper determination.
GR case may be state, my lord. GR case may be state for the time being, my lord.
No, okay, GR case stay means
Well, the
no proceeding has yet been started.
Well, started, my lord. In the court, my lord, it is going on, my lord.
What proceeding is started?
The GR case is started, my lord. No, my lord. Though, my lord.
Only copy has been supplied.
Yes, my lord.
Charge has not yet been
That is true, my lord. Kindly stay this for the time being, my lord.
No. Unless any proceeding should not be a start initiated.
That is true, my lord.
Then let the proceeding be started. Then we will pass order for the stay.
The problem is that, my lord, hearing matter is not taken up. My lord knows, my lord. That's why, my lord, I am staying, my lord.
No. Your matter will appear in the year of 2026. Why?
Then, my lord, the proceeding will be finished, my lord. Then what will I use of, my lord, filing this?
Come after service. Thereafter, In presence of both sides, any such order will be passed.
Okay. Item number 11.
11, my lord, I am the petitioner in this present case and I am the de facto complainant. My lord, same the complainant in the serial number 9. Here the complainant is the Papia Manta. She is a widow of an army jawan, and I am praying before your honor for the.
How many cases you are filed?
No, this means she has been aggrieved, my lord. My lord kindly
Yeah.
comes to
The
after
number of cases will give her respite.
My lord, in this, my lord kindly comes to page number 14. After the death of her husband, she was thrown out of her matrimonial house. And in this, and when she
Same allegation, same party.
no, same party, but allegations here are different. And thereafter, when she goes to the cantonment board, my lord kindly comes to page number 14, annexure P1. To get the death certificate of her husband, she comes to know that my lord kindly comes to page number 16, 16. Now this page number 16, 16, my lord.
Yes.
This first authorization letter was submitted before the cantonment board, Barakpur, by his brother-in-law, that is namely Ripan Manta, to get the death certificate. My lord kindly comes to page number 29.
Yes, charge sheet.
This charge sheet was framed. My lord will see.
When charge sheet was framed?
My lord. The charge sheet was framed.
Filed on?
9/10/23. My lord kindly comes to page number 31 of this charge sheet, where the report of the question document examination.
What is the stage of trial? What is the stage of trial before the court?
It is, my lord, only the copy has been supplied to the accused person and the trial has yet not commenced. They are on the bail. They are continuously threatening the petitioner of this instant petition. My lord kindly comes to the order dated 5/6/24. Where even through the put up petition, this prayer was made for the expeditious disposal.
For early trial, yes. Prayer is allowed. You should notice.
Yes, thereafter, my lord, thereafter also there is no progress of the case, my lord.
For appearance and copy.
Yes, thereafter also there is no progress, my lord. And very sorry to say, my lord, the conduct of the investigating officer since ab initio was absolutely bad. They have been very well manipulated by the accused person.
That this case has been transferred to the SCGM court for disposal. Record is put up. Hmm.
14/12/24 was the date fixed for appearance, and still it is at the appearing stage, my lord.
Same kore dao.
Then 94.
Take down. যে আগে নিয়েছিলে তো তুমি আসো আগে যে দিয়েছিলাম expeditious disposal এর জাস্ট আগে এর আগে যে
সিরিয়াল নাম্বার 9
ওই ভিত্তিতে যাবে একটু কেসলেস নাম্বার দেখে নেবে same case number Barakpur police station case number everything is same.
My lord, it is Jagdal PS case number 103 of 2022.
দেখে নেবো দেখে ওই সেম অর্ডার only সেকশন আর ইয়ে সব চেঞ্জ করে yes order yes Call the list.
Item number 12.
Madam, for the petition.
Yes.
But I'm praying for quashment of the proceeding. But petitioner number 2 is an advocate of DRT, renowned advocate, and petitioner number 3 is the wife, and petitioner number 1 is the husband. My lord, petitioner number 2 and 3 both are senior citizen. My lord, after kindly comes up to the FIR. My lord, FIR states on 11/10/2023, she was driven out from her matrimonial house, but FIR was lodged on 24/3/2025 after 1 year and 9 months. But there are in between what has happened, they entered into a compromise. MOU is there. I have handed over all the Sridhan articles. Divorce proceeding has been filed. 50,000 rupees has already been handed over to her. After that, my lord, everything done. Now she has filed this case. Now, my lord, I'm relying on a case of Supreme Court in a similar facts of case, but where after compromise, once compromise arrived, they can't
File this case before the trial court.
my lord,
Where trial is going on, you file
but I'm
such authority before.
no. I'm before your lordship, and in 482, I'm sorry, my lord. I'm sorry.
Do you think that at the time of admission hearing,
I'm sorry.
should I quash today?
No. I'm sorry. My lord, so far MO is concerned, my lord, kindly comes to page number 36.
You apprised only those facts.
Yes.
In support of admission of this case.
Lordship.
Whether this case should be admitted or not.
Lordship.
This-
Page
that
number
much is-
36. My lord, the MOU.
Page number
36.
36.
By and between the parties, paragraph number 11. That is page number 39. Dissolution of marriage, we have done that.
No,
Divorce
marriage is not disputed. Marital relationship was there.
Yes. I am not
This is
disputing that.
admitted fact.
I am not disputing that. But what I am on, but there was no mental harassment, physical harassment to show that. But kindly see page number 26.
These are disputed question of fact.
I am showing that prima facie, my lord, that it is wrong. Kindly see page number 26 once.
27.
But it is the chat with me.
That could not be a basis for taking judicial notice.
My lord, so far case is concerned, but then kindly comes to return of Sridhan articles, page number 57.
57, yes, I am there.
Yes, my lord.
One necklace, 2 gold, 2-piece gold, one set. Yes.
But I have handed over the everything.
Yes.
Now, my lord, 58. That is money paid in lieu of furniture which she provided in the at the time of marriage.
Yes.
Now, my lord, MOU I have shown. Now, my lord, divorce petition is also there. That is page number 44 to 55. There also she has written that everything done. That is in paragraph number 16.
What is the stage of divorce petition?
My divorce petition is pending now. After filing divorce petition.
13B or 13?
13B. There she.
Since when the petition is filed?
Valid?
Since when divorce petition is pending?
But before filing this case.
Then why don't you expedite that case hearing of divorce petition first?
But now what has happened after filing divorce petition, after
That will resolve your all problem.
after taking money, now she is not coming. This is what the problem arises.
She need more money.
She is simply harassing us. After 1 year and 9 months, this case has been filed. After taking everything, when compromise took place, now she is doing such an act, my lord.
Children?
No, there is no children. But just once, if your lordship sees the message where she is admitting that আমি ভালো ছিলাম, সবকিছু বুকের কাছে পেয়ে
They
যেতাম.
cannot consider upon those matters.
Lordship. So far, my lord, FI is concerned, that is also general and omnibus. And my lord, there is no specific date in what date the torture was committed. And so far, my lord, the 161 after 207, we have received the 161. My lord, that is in yes, that is in page number 40. Yes, 58. They are also
161.
yes, my lord, 161 of mother and father of the petitioner, but there are also no specific date. Only
No, page number 58 is the receipt.
62, my lord, 62, 63. Entirely general omnibus allegation, and only one date make a tadiye দেয়. Both 62 and 63.
Make a tariyada is sufficient to attract which sections are there?
But 498 only. She is
The
not claiming
498 is
406.
sufficient to attract
My lord,
498.
when there is
Make a
no
tariyada is sufficient.
when
Ranu
there,
is not a very furnish a very good sense.
Right, just
If
I'm
use tadiye cho kakeo, that is
That-
not good.
that is true, my lord. I have
Tarano they sufficient to attract 190 498.
right now. If make a
Okay.
tadiye there, then my lord kindly considers 406 is not there in the FIR. She took all her belongings. Why? My lord, I can show why. That is in
Yes, prima facie it appears that relationship is not good.
yes, my lord. Why? That the reason behind it, my lord, I am not reading. I have craved leave. My lord, kindly sees this. Why? She had a illicit relationship with one.
Not required to disclose everything here.
Yes, that's why I'm not. I'm just, my lord, giving your lordship that why. Reason
You
behind-
again you again submit those please. Not. Yes, take down. Petitioners are the husband and in-laws of OP number 2. Learned advocate for the petitioner submits that they have been falsely implicated in this case and the allegations are false and omnibus in nature. He referred page number 44 and 45, page number 44, 45 and 58 to show what is there in page number 44, 45?
But 44, that is mutual divorce petition, and
That is at page number 46. Page number 46. To show that an application under section 13B of the Hindu Marriage Act 1955 is pending before the court of learned district judge at Alipur, and
57-58.
page number 53. No. Where is the receipt of payment? Yeah.
My lord, that is 58.
Full stop down. He also referred page number 57 to show that the Istri Dhan of OP number 2 was handed over on 14th, were handed over on 14th January 2025. And as 50,000 rupees were paid against the furnitures gifted by her to petitioners at the time of marriage under a proper receipt dated 14th January 2025. He also referred page number 62, the statement of Paushali De, and 63, the statement of Babul Chandra De, recorded under section 161 of CRPC to show that there is no merit in the allegation. Upon perusal of the application and hearing the submission of learned advocate for the petitioner, it is evident trial has not yet been started.
No, next date is fixed for charge.
The trial has not yet been started, and prima facie sufficient material is available to admit this record, admit this application. Accordingly, the CRR is admitted. Learned advocate for the petitioner is directed to service direction दिया था. OP number 1 and OP number 2 are 8 week. बाद में कि ठीक है.
But kindly gives me stay, my lord.
No, no proceeding has yet been started. So no such order.
Next date fixed for framing of charge. Then my lord kindly gives us liberty to pray for adjournment.
You come after 8 week and you make your submission before the court.
My lord, I am saying, my lord, next date fixed for framing of charge in the month of November. My lord, otherwise it will go on.
That matter will also appear in the month of November.
if
Let the
takes a-
proceeding be started. Till now, no proceeding is started before the trial court.
But it kindly gives me an direction to pray for pray for adjournment for 1 day only.
Where?
Trial court, before the trial court, unless
For that direction is not required. Trial court will not run upon our direction. Let them do their work. Item number 1 of this. Why this matter not appear in this? আমি তো বলছি না যত এক্সটেনশন জানে আছে দিয়ে দিতে হবে কালকে সব যত আছে অ্যাপ্লিকেশন পেন্ডিং सबके ऊपर করে দেবে আগে অ্যাপ্লিকেশন সবই হবে
আচ্ছা রেস্ট অফ দ্য ম্যাটার কি আজকে রিলিজ
where is the record
মানে রেস্ট অফ দ্য ম্যাটারস আর রিলিজড ফ্রম
Yes.
13
thank you yes where is the record
Page 7 of page 7.
then what is the stage of the investigation just a minute.
During investigation, one is 160 notice has been issued against the de facto government in this case.
Yes.
He was present at the time of investigation.
Hmm.
He was interrogated. Thereafter came back. After 1 day, on the evening, 1 day after, this complaint has been lodged against the investigating officer.
Then what is the stage of complaint?
Thereafter, this case has been started by the local police station. Entire proceeding has been, in order to frustrate the coal scam case, that's why one man filed a case against the investigating officer. That's why I came before this honorable court. Honorable court stayed the entire proceeding, and it has been extended for a 13 times. Now 14 times before your lords.
No, so how many time?
I am ready. Keep it any day. I will complete the matter. Actually, state is not interested at all.
Then let them not interested. Will hear and pass order accordingly.
To kindly fix a date and for the
Yes.
timing, extend the and case diary is necessary for disposal this case. Disposed of this case.
So I am
Now, extend the interim order and fix the.
I am granting a extension as a last chance. Will not give any further time.
It is not my fault.
In the meantime, both
Here and now I am ready.
you come na. You come.
Yes.
Thereafter we'll see.
Yes, ma'am.
Thereafter we'll see.
Now extend the interim order for a limited period. Yes.
अभी ये बंद कर दो. दयविಟ್ಟು बंद कर.